Good morning.
Good morning. How are you today?
Fine, you.
I'm well, thank you for asking. At your pleasure, we've got all the files. We have a council ready, so bring them at your pleasure. Thank you.
Okay, let me. I need to go. Yeah, Greg. Yeah, all of
Sister Council, did you have an opportunity to interview Mr. Jordan at MDOC? Do you know? Okay, thank you.
Your officer here today?
Yes. Yes, somewhere.
I'm going to here. What's your first name? Antoine. Antoine. Yeah. You got a middle name? Ricardo. You'll be first name. Green. There you go.
We have one from Division 1. Good morning. Have you spoke with Mr. Walls? Or whoever this gentleman is? Good morning, Division 1. Who do you have in front of the camera, sir?
Keith Walls.
Keith Walls? Have you spoke with Keith Walls? Mr. Walls, have you spoke with an attorney this morning, sir?
Yes, sir.
Okay, 1 second. They're getting some information to represent you, and then we'll handle the matter. 1 second.
Right, on this day, the judge gives you a $7,000. You got court date 13, December 18th.
These were never exams. Are you ready on Mr. Walls? Okay, you're welcome. Thank you. Good morning, sir. Could you state your name, please?
Keith Walls.
Thank you. You're here for case 190449444, People State of Michigan versus Keith Matthew Walls. Counsel.
For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Keith Walls here for room and standing the wait for reading of the information as the plea of not guilty entered on his behalf.
Thank you, counsel. Court waive formal reading and her plea of not guilty. The court scheduling a pre-trial date. Stand by, Madam Clerk. Both the same. All right, can I get a personal on this one for 5? It's going to be a personal bond on that one.
I think it's the same date, Your Honor. This is whether it's a personal one.
Right, I don't think we have a personal admit though, did we?
I know we don't need a personal because the dates are the same.
Oh, but the bond is up to 10% bond.
Yeah.
Then here's
Oh,
the,
on one of them is,
on all of them it has a 10%.
oh, because it's a capious.
Right, but they're misdemeanors, so I'm gonna change it. They're not exam judges.
Okay. Oh, okay, so this is the one that was passed. Okay.
Right, the only ones that don't change is if they have like exam judges, right?
Okay.
Sorry. Yeah. Okay, court waive formal reading and her plea of not guilty and schedule a pre-trial date. Mr. Walls, you must attend December the 14th, which is a Monday, 8:30 a.m., 36th District Court in front of Judge Bryant. Mr. Walls, that hearing will take place via Zoom. That's an off-site streaming technology. Before you're released, you'll get information on how to connect for that Zoom hearing, but it is your responsibility to connect on time. Do you understand?
Yes, sir.
Thank you. Not guilty, please enter Esteban.
Thank you, Your Honor. I believe on asking for current public
Thank you, Father. No, I should have. My bad. Excuse me? Go ahead. Thank you. Mr. Walls, what happened on October the 8th, sir? Why did you fail to appear to court? Thank you.
I've been in the Wayne County Jail, sir.
So you were never released? You were in the Wayne County Jail on October the 8th? You weren't brought over for the court hearing? Is that what you're stating?
Yes, sir.
Officer, is there any verification of that? That he was incarcerated and not brought over? Excuse me?
Checking on that right now, Your Honor.
I appreciate that. Thank you, sir. Mr. Walls, this is a serious allegation, sir. During this bond, you are not to purchase or possess a firearm or any dangerous weapon, and do not go back to the area or premises of Latino Family Services at 1145 Lawndale, Detroit, Michigan. Do not go to that premises or area. Is that understood?
Yes, sir.
Thank you.
Your Honor, Mr. Walls has been in the custody of the Sheriff's Department since September 15th. I don't think this case was entered into our jail management system. That may have caused him to miss this court date.
I appreciate that information, officer. Thank you. So, Mr. Walls, it's very important that you attend the court date. The court takes into consideration the information provided by the officer where you're being housed, as well as your counsel. And the court is going to reinstate the original bond that was set before the capias was issued in the amount of $5,000 personal bond. You're being released, Mr. Walls, on a personal bond for the reasons stated. Do not purchase or possess a firearm or any dangerous weapon, and absolutely do not go to the premises or area of 1145 Lawndale, Detroit, Michigan. That's the Latino Family Services. Is that all clear?
Yes, sir.
Okay, good luck, Mr. Walls. You have that Zoom hearing on December 14th, which is a Monday, in front of Judge Bryant, 36th District Court. I hope it works out for you, sir.
Thank you, Your Honor.
You're welcome. Thank you, Claudia. Good morning. Your name, please.
Walter Johnson.
Thank you, Mr. Johnson. And you're here for case number 200611817, People State of Michigan versus Walter Michael Johnson. Sister Counsel.
Record, Your Honor, we had Stephen Son appearing on behalf of Walter Johnson, waive the reading of the information.
Court waive formal reading of the information under plea of not guilty. Mr. Johnson, the court scheduling 2 court dates, sir, that you must attend them both. Probable cause conference, Wednesday, November 25th. You have a right to a preliminary examination the following Wednesday, December the 2nd. Both at 8:30 a.m., 36th District Court in front of Judge King. Both of those hearings, Mr. Johnson, will take place via Zoom, which is an off-site streaming technology. You'll get information on how to connect for those Zoom hearings before you're released, but it is your responsibility to connect on time. Do you understand?
Yes, sir.
Not guilty. Please enter it as the bond.
Thank you, Your Honor. Mr. Johnson, that the court knows that you intend to communicate contact with the concerning matter. He is employed, sugar fund staffing, Your Honor, basic staff. Does have some medications that he's taking, Your Honor, but I'm not sure he's taking them.
Could you please mark his file medical for the reasons stated by counsel, officer?
You understand the serious nature of the charges, Your Honor. I'm going to ask the court to consider personal bond in light of the current public health crisis, Your Honor.
Thank you.
Sorry, Your Honor, were you referencing the jail to mark him as medical?
Yes, please.
He is currently housed on a medical ward.
I appreciate that information, officer. Thanks again. Mr. Johnson, this is a very serious assaultive allegation. The court has concerns, specifically the allegation count 1, which is a life offense. Also, court takes in consideration your prior felony convictions, which are numerous felony convictions, including convictions for assault of nature. The court has noted ties to the community, the current epidemic facing the nation. The court takes into consideration, as well as your employment status and information stated by counsel as it relates to the ability to post bond. The court also takes into consideration the likelihood of conviction as indicated in the allegations set forth in the investigator's report. Mr. Johnson, during this bond, sir, you are not to purchase or possess a firearm or any other dangerous weapon, and absolutely no contact with Reno Johnson. No contact means no contact of any kind. No contact orally, in writing, through a third person, at their place of residency, employment, or through any forms of social media. Absolutely no contact. Do you understand?
Yes, sir.
Given that your prior felony convictions, the information placed on the record, the serious nature of this charge, bond on this matter will be set in the amount. $125,000, 10%.
Thank you, Your Honor.
Good luck, sir. Officer, do you have anybody else for this morning's docket?
Nobody from Jail Division 1, Your Honor.
I appreciate your help this morning. As always, have a nice day and be safe, sir.
You too, Your Honor.
Thank you. Thank you, DDC, for your patience. We handled a couple matters at Division 1. Whenever you're ready. Good morning. Your name, please.
Anton Evans. Ricardo
Thank you,
Evans.
Mr. Evans. Thank you, sir. You're here for case 2006193, People State of Michigan versus Antone Evans, also known as Antone Ricardo Evans, Antoine Evans. Counsel. Thank you, sister. Counsel, court will waive formal reading and her plea of not guilty. Mr. Evans, the court is scheduling 2 court days, sir. You must attend them both. Probable cause conference November the 30th, which is a Monday. You have a right to a preliminary examination the following Monday, December the 7th. Both at 8:30 a.m. 36th District Court in front of Judge Archer. Mr. Evans, both of those hearings will take place via Zoom. That's an off-site streaming technology. You'll get information on how to connect for those Zoom hearings before you release or make bond, but it's your responsibility to connect on time. Do you understand?
Yes, sir.
Thank you, Mr. Evans. Not guilty is entered as the bond. What was that last part, counsel?
Mr. Evans wants the court to know that his blood pressure has been elevated since incarceration.
Please, officer, please mark Mr. Evans filed medical for the reasons stated by counsel.
Thank you.
Right.
Thank you.
And Mr. Evans will have no contact with the complaining witness, Your Honor, or that Lanesdale address. He has given us an alternate address, Your Honor, indicates that he'll be living on 10th Street in the city of Detroit. Therefore, no need to have any contact with the complaining witness or the location of the alleged incident. Mr. Evans, due to the serious nature of this public health crisis,
Greenhead.
I noticed that it's one of those prior.
Thank you, sister counsel. Mr. Evans, the court takes into consideration the information provided by your attorney who's advocated well on your behalf. It appears you have ties to the community, no capious history the court's aware of. These are very serious assaultive allegations. The court considers your prior criminal record and the nature of those charges and convictions as well as age. The court's read and reviewed the investigator's report and takes into consideration the allegations set forth therein, as well as considering the current epidemic facing the nation and employment status as it relates to ability to post bond. And it does appear you have ties to the community. Mr. Evans, during this bond, you are not to purchase or possess a firearm or any dangerous weapon. Absolutely not to go to the area or premises of 2231 South Liddensdale, Detroit, Michigan. And no contact with Tanisha Porter and no contact with Autumn Evans. No contact with both of those individuals means no contact of any kind. No contact orally, in writing, through a third person at their place of residency, employment, or through any forms of social media. No contact with Tanisha Porter. No contact with Autumn Evans. Is that all clear?
Yes, sir.
Thank you. And if you're able to make bond based on the serious nature of these allegations, the concerns the court has regarding their alleged victim safety, you're to be fit with a GPS tether. For those reasons, bond is set $5,500, 10%. Good luck, Mr. Evans. You're welcome.
All right. Thank you, sir.
You're welcome, sir.
They gotta take you different though.
Thank you. Good morning. Your name, please.
Bernius.
Thank you, Mr. Bernius. And good morning, counsel. Who do you have, sir?
Judge, I have Jordan Armstrong, who's in the waiting room right now.
Okay.
He's scheduled by Ms. Gray.
Okay, we're going to finish this matter, and then we'll handle Jordan Armstrong next. Let me take care of this arraignment, okay, counsel? And then you'll be on deck.
Thank you very much. No rush.
Thank you for your patience. Thank you, Mr. Brunius. I apologize. Sir, your name one more time? Thank you, sir. And you're here for a couple of matters, sir. We'll get through them one at a time. First, we're going to handle case number 18059-249, People State of Michigan versus Eric Brunius, identified in the complaint as defendant 2. Counsel? Thank you. Mr. Brunius, court waive formal reading, enter plea of not guilty, sir. The court scheduling 2 court dates. You must attend them both. A probable cause conference on Wednesday, November 25th. You have a right to a preliminary examination the following Monday, November 30th. Both at 8:30 a.m. 36th District Court in front of Judge Giles. Both of those hearings, sir, will take place via Zoom. That's an off-site streaming technology. You'll get information on how to connect, but it's your responsibility to connect on time. Not guilty is entered as the bond. There is, yes. He didn't have paperwork? Thank you. Okay, Mr. Brunius, you were arraigned on this matter by Magistrate Boyer while you were incarcerated, correct?
Yes, sir.
Right, so you were given information before you left court. You were given paperwork with all of that information. The court sends over paperwork, just as we're going to do today, not only telling you of your new court date, but also information on how to connect for Zoom. And sir, that arraignment took place May 21st of 2020. So that was a number of months ago. So if you were released, it was your responsibility, sir, to contact the appropriate individuals and figure out how to appear for this Zoom hearing. And when you failed to appear, Mr. Brunius, on about November the 2nd, 2020, the judge you were assigned to, sir, issued a warrant for your arrest and placed a bond in the amount. Mr. Brunius, I have no authority to change that bond, sir. During this bond, you are not to purchase or possess a firearm or any dangerous weapon. No weapons. Do you understand, sir?
Yes, sir.
Thank you, Mr. Brunius. I hope all works out well for you. It's very important you attend your court date. Bond on this matter set by the judge you are assigned to when you allegedly failed to appear for the preliminary examination in the amount of $30,000 cash surety. Mr. Brunius, you have one additional matter. Please state your name again. I apologize, Mr. Brunius. Your name one more time, sir? Thank you. And this is case 2005841. People State of Michigan versus Eric DeMar Kenneth Brunius, also known as Eric Brunius, Eric DeMar Kenneth no hyphen Brunius, counsel. Thank you, sister counsel. Court waive formal reading of the information under plea of not guilty. As with the latter matter, Mr. Brunius, the court scheduling 2 court dates, sir. You must attend them both. Probable cause conference on November the 25th, which is a Wednesday. Sir, the court scheduling a preliminary examination, which you have a right to, the following Monday, November the 30th. Both 8:30 a.m., 36th District Court in front of Judge Giles. Both will take place via Zoom. As stated, that's an off-site streaming technology, which you will get information on how to connect. Not guilty is entered as to bond counsel. This is also capious. Thank you, sister counsel. And Mr. Brunius, as with the latter matter, sir, you're here because you allegedly failed to appear for an examination. This one on or about November 16th of 2020. And when Mr. Brunius, when you failed to appear, the judge that you were assigned to issued a warrant for your arrest and placed a bond in the amount. I, as a magistrate, have no authority to change the bond. During this bond, as well as the latter bond, you are not to purchase or possess a firearm or any other dangerous weapon. Mr. Brunius, the bond was set by the judge you were assigned to, as stated, when you failed to appear, which you have no authority to change, in the amount of $30,000 cash surety. Good luck, Mr. Brunius. I hope everything works out well for you, sir. Make sure and make the court date. The 2 dates, November 25th, probable cause, and November 30th, preliminary examination. Thank you. And DDC, if you could wait one moment, we have a counsel on the phone that's about to handle an arraignment. If you just give us one moment, thank you. Counsel, good morning. And you have Mr. Armstrong?
Yes, Judge.
Thank you. Good morning, Mr. Armstrong.
Good morning.
Could you state your full name, please?
Jordan Von Armstrong.
Thank you. And this is for case number 200611574, People State of Michigan versus Jordan Von Armstrong. Your appearance, please.
Good morning, Judge. Patrick Nineheist, P76343, on behalf of Mr. Armstrong. We consent to a Zoom hearing today, and I did file an appearance through the e-file system this morning.
Thank you, counsel. As to the arraignment, sir?
We'll waive the formal reading of the arraignment on the warrant, Judge, and stand mute to the charges at this time.
Thank you. I've got it. I wrote it. His P number? Yep, I wrote it down. Yep. The court will waive formal reading and enter plea of not guilty. Mr. Armstrong, the counsel of the court scheduling a probable cause conference. Mr. Armstrong, you must attend on December the 16th, which is a Wednesday. That's 8:30 a.m., 36th District Court in front of Judge King. Mr. Armstrong, counsel, that hearing will take place via Zoom, similar to what we're using today. Mr. Armstrong, that is your responsibility to connect on time for the Zoom hearing in front of Judge King, 36th District Court on December the 16th at 8:30. Do you understand, sir?
Yes.
Thank you. Not guilty is entered. Brother counsel, as to bond.
Judge, he's got a full-time job. He's got a lifelong resident of Metro Detroit. We rented him out. He turned himself in today. He's got retained counsel. I'm asking for a personal bond. He's got no prior criminal history, no failure to appear. The gun was legally purchased, and he had taken the seatbelt class. Was merely waiting for the date to get his actual CPL.
Thank you, counsel.
Thank you, Judge. So this is either a diversion case or a misdemeanor that will likely result.
Thank you. Brother counsel, Mr. Armstrong, the court takes into consideration the information provided by your counsel, the fact that you were written out as stated and you did appear for the Zoom hearing. The court considers, as well as the serious nature of this charge, Mr. Armstrong, which is extremely serious, but it is non-assaultive. The court considers the ties to the community as well as the current epidemic facing the nation. During this bond, Mr. Armstrong, also it appears you have ties to the community, and the court considers your employment status as stated by counsel as it relates to the ability to post bond. During this bond, sir, you are not to purchase or possess a firearm or any other dangerous weapon during this bond. No weapons. Is that understood?
Yes.
Thank you, Mr. Armstrong. And for those reasons, your bond is set in amount $5,000 personal bond. Anything further, counsel?
No, Judge. Did you give us an exam date or just a probable cause date?
I gave you just a probable cause date. It's a personal bond, so we're just giving just probable cause dates.
Okay, thank you, Judge. I just wasn't sure if I missed it. I appreciate it.
Nope, I appreciate the question. Anything further, counsel?
No, Judge. Thank you.
Good luck, sir. Good luck, Mr. Armstrong. I hope it all works out well. Listen to the court, sir.
Thank you, and we'll talk soon, Mr. Armstrong.
Okay.
Thank you, DDC, once again. I appreciate your assistance. Ready when you are.
How you doing?
Good morning.
How you doing?
Your name, please? I'm well, thank you, Mr. Larkin. Thank you. I'm well, Mr. Larkin, and good morning to you, sir. Mr. Larkin, you're here for case number 180612471. People State of Michigan versus Jarnis Jarrell Larkin.
Yes, sir.
Court will waive formal reading and a plea of not guilty. Mr. Larkin, the court scheduling 2 court dates, sir, that you must attend them both. A probable cause conference on November the 25th, which is a Wednesday. Mr. Larkin, you have a right to a preliminary examination the following Wednesday, December the 2nd. Both scheduled 8:30 a.m., 36th District Court in front of Judge King. Both of those hearings, sir, will take place via Zoom, which is an off-site streaming technology. Before you're released or make bond, you get information on how to connect for those Zoom hearings, but it is your responsibility to connect on time. Do you understand, Mr. Larkin?
Yes, sir.
Thank you, sir. Not guilty, please enter. This is a capias as to bond.
Mr. Larkin is living in the Detroit area. His entire life is 26 years old, Your Honor. I think the only other thing that matters is the court for bail on track. Mr. Larkin is absent.
Thank you, Sister Counsel. Mr. Larkin, this is a serious allegation, sir, but it is non-assaultive. The court notes the information provided by counsel, the current epidemic facing the nation, as well as your employment status as stated, as it relates to ability to post bond, and it appears you do have ties to the community. During this bond, Mr. Larkin, there's absolutely no use of alcohol, no marijuana, no illegal controlled substances, and you are not to purchase or possess a firearm or any other dangerous weapon. Is that all understood?
Yes, sir.
Mr. Larkin, it's very important you listen to the court, sir. On or about December 13th of 2018, you had a probable cause conference scheduled where it alleged you failed to appear. The judge that you were assigned to, sir, when you failed to appear, issued a warrant for your arrest and placed a bond in the amount. I, as a magistrate, have no authority to change the bond. I cannot change the bond. It was set by the judge that when you miss court. It's very important you attend court dates, Mr. Larkin, so you don't get locked up simply for not showing up for a hearing. And the bond was set by that judge for the reason failing to appear on the date for this hearing stated in the amount of $25,000 cash surety. Good luck, Mr. Larkin. I hope it all works out well for you, sir.
Can I say?
Yeah, anything that you'd like, sir.
Sir, I had they gave me a personal bond on that case, and then they sent me to Dickinson, and I took care of my traffic tickets. I didn't know nothing about the court date on the 13th, where I would have showed up like I showed up for the court date for the tickets. I would have went, sir, if I knew about it. I didn't know.
So, Mr. Larkin, you were given information. You were arraigned on this matter, and you were given court dates when you were arraigned. And it's your responsibility to attend the court dates. This is a felony allegation, sir, it's an allegation of a possession of a controlled substance, heroin. So when you went to court to handle traffic matters, you should have looked into this. Where is this allegation that I was picked up on regarding a felony drug case? And if you would have looked into it, you would have seen you had a warrant, or you would have had a case pending. So it's very important you attend court dates, Mr. Larkin. Mr. Larkin, and I wish you the best of luck, sir. As stated, I have no authority to change that bond. A bond is addressed and reviewed at any stage of the proceedings. So you can, your counsel can readdress bond as they choose to do so. But at this stage, Mr. Larkin, I have no authority to change the bond. I hope it works out for you, sir. Good luck.
There's no way you can continue the bond? There's no way you can continue the bond so I can just go to court?
No, there was no bond to continue, sir. You forfeited any bond once you failed to appear.
Because you failed to appear. That's that 25,000 cash. He didn't assign it to you, the previous judge did.
So how am I going?
Good luck. Good morning, counsel.
Good morning, Your Honor.
Who do you have?
Cornelius Colton. It was a waive. It was a. I read them out, and they gave us a court date and time for today.
Okay. Well, is that him? Is that him on the screen with you?
Right here,
Mr. Colton.
Yes. Yes.
Okay, both of you, Mr. Colton and brother counsel, please be patient. We'll handle your matters next as soon as we finish this gentleman on the screen. Okay.
Thank you, Your Honor.
Okay.
You're welcome. Good morning, sir. Your name?
Diaz Erasmo.
I apologize. Your name again, sir?
Erasmo Diaz.
I appreciate that. Good morning, Mr. Diaz. Mr. Diaz, you're here for case number. Are you a junior, sir?
Yes.
Thank you. You're here for case number 190463332, People State of Michigan versus Erasmo Diaz Jr. Counsel. Thank you. Court waive formal reading and her plea of not guilty. Court scheduling a pretrial date. Mr. Diaz, you must attend December the 9th, which is a Wednesday, 8:30 a.m., 36th District Court in front of Judge Garrett. Mr. Diaz Jr., that hearing will take place via Zoom. It's an off-site streaming technology. You'll get information on how to connect, but it's your responsibility to connect on time. Do you understand?
Yes, sir.
Thank you. Not guilty is entered as the bond.
Thank you, Your Honor. Mr. Diaz wants to report to the court. He did not live with the complaint of Mr. Garcia, and he's been advised to set up the contact during the pendency. Yes, while the court penalty has been working, doing some mechanic construction work, we would look on her children, want to remain in the community, and able to parent them. is requesting personal items must be into the deed.
Thank you, Sister Counsel. Mr. Diaz Jr., this is a very serious assaultive allegation, sir, and the court considers your prior felony or your prior criminal convictions, which includes a conviction of a similar related nature. It's very concerning to the court. The court notes you have ties to the community. The court's considered the current epidemic facing the nation, as well as the information provided by counsel, including but not limited to your employment status as it relates to ability to post bond. Mr. Diaz Jr., the court also has read and reviewed the investigator's report and taken into consideration the information outlaid therein and the concerns the court has regarding the individual alleged victim's safety. Mr. Diaz Jr., during this bond, sir, there's no use of alcohol, no marijuana, no illegal controlled substance, and you are not to purchase or possess a firearm or any other dangerous weapon. Is that understood?
Yes, Your Honor.
And do not go back to the area or premises of 3658 Clipper, Detroit, Michigan. Absolutely no contact during this bond with Erica Garcia. No contact, Mr. Diaz Jr., means no contact of any kind. No contact orally, in writing, through a third person, at her place of residency, employment, or through any forms of social media. Absolutely no contact with Miss Garcia. Is that understood?
Yes, sir.
Given the presence of threats in the investigator's report, the allegations set forth therein, and the information placed on the record, you're to be fit with a GPS tether prior to release. Your bond on this matter set in the amount $2,010%. That's $200, Mr. Diaz Jr. Good luck, sir. DDC, please stand by. We have an attorney on Zoom that we're going to handle one matter. Thank you. Thank you for your patience, brother counsel.
You're welcome, Your Honor.
Okay. And then your name, sir, Mr. Colton?
Cornelius Colton.
Thank you. And good morning to you, too. This is case 200-61596, People State of Michigan versus Cornelius Colton. Your appearance, please.
Good morning again, Your Honor. Ivan Land, P65879, appearing on behalf of Cornelius Colton, who's on the screen, Your Honor. As for arraignment purposes, you can waive the formal reading, Your Honor.
Thank you, brother counsel. Court waive formal reading under plea of not guilty. Schedule a probable cause conference, Mr. Colton, that you must attend on December the 16th, which is a Wednesday. That's at 8:30 a.m., 36th District Court in front of Judge King. Mr. Colton, that hearing, sir, will take place via Zoom. That's an off-site streaming technology similar to what we're using today. You'll get information on how to connect, but it's your responsibility to connect on time. Not guilty's entered as the bond.
Your Honor, Mr. Colton received a $10,000 10% bond from Judge Deborah Ford. I was just asked that the court continue that bond in this matter, Your Honor.
Thank you. Is there any other information the court you would like the court to take into consideration?
Yes, Your Honor. He's a city Detroit resident, Your Honor. He lives with his mother. He works, Your Honor, and most importantly, he's retained counsel at this early stage, Your Honor, and he's appeared on Zoom one time today, like he was told to. I was just asking for the bond to be continued. Thank you.
Thank you, brother counsel. Mr. Colton, the court takes into consideration the information provided by your attorney, who's advocated well on your behalf. You have ties to the community. You have appeared as stated by counsel via Zoom at counsel's direction. Court notes the information alleged in the investigator's report, as well as the nature of this charge, which is extremely serious, Mr. Colton, but it's non-assaultive. You do have ties to the community, it appears. The court's considered the current epidemic facing the nation, as well as employment status as stated as it relates to the ability to post bond, and as reviewed and considered the information alleged in the investigator's report. During this bond, Mr. Colton, you are not to purchase or possess a firearm or any other dangerous weapon. Is that understood? No weapons.
Yes, Your Honor.
And for those reasons, sir, bond is set $10,000 personal bond. Anything further, brother counsel?
Oh, no, thank you so much, Your Honor. Stay safe.
Thank you.
You too. Thank you, sir.
Appreciate that, Your Honor. Thanks a lot. Take care.
Thank you.
Thank you once again, DDC. At your pleasure. Appreciate your accommodations.
Hold on now. You need somebody else, Kenny?
Yeah, you ready?
Okay, what thing?
Here, start from here.
Yep. I got George Harris.
Good morning. Your name, please. I apologize. Your name one more time.
George William Harris III.
Thank you, Mr. Harris III, and good morning, sir. You're here for case 200-454. Thank you. 200-45484, People State of Michigan versus George William Harris III. Sister Counsel.
Thank you, Your Honor. The record manager, Stephen, hearing on behalf of here, later written information, substantially that this is not guilty and right in the past.
Court will waive formal reading of the information and enter plea of not guilty. Mr. Harris, the court's scheduling pre-trial date, sir. You must attend December the 9th, which is a Wednesday, 8:30 a.m., 36th District Court in front of Judge Garrett. Mr. Harris, that hearing, sir, will take place via Zoom, 8:30 a.m. That's an off-site streaming technology. Before you're released, you'll get information on how to connect, but it's your responsibility to connect on time. Do you understand?
Yes, sir.
Thank you, Mr. Harris III. Not guilty. Please enter as to bond.
Your Honor, Your Honor, 24 years old, he is a veteran of the United States Navy.
He's a veteran?
Yes, Your Honor.
How were you discharged, Mr. Harris?
Administrative discharge because of my mother's illness before she passed.
I'm sorry to hear that, Mr. Harris III, and I appreciate your service.
Appreciate it.
Sorry, Sister Counsel.
Thank you, Your Honor. Prior to this, somebody attended, Harris was working as a maintenance man. Right now, he's not working in employment. Is living with a friend, will have absolutely no contact with the complaint with Ms. Ashley Carter. I do know that the victim is alleged to have been doing part of this year's honor, someone has passed. Since the day of the election, and Mr. Harris, you have no contact with Ashley Carter. What the court is now, Your Honor, he is seeking personal law, Your Honor, and I've asked the court to take into consideration the current public health crisis. But general try to set Mr. Harris, he said as well, I believe that personal law, no contact with Ashley Carter.
Thank you, Sister Counsel. Mr. Harris III, the court considers a number of things upon imposition of bond. The court considers the information and advocacy provided by your attorney, who has done well, as always, advocating on your behalf. You have ties to the community. The court considers, as well as no criminal convictions or capious history that the court's aware of. The court does consider, as stated by counsel, the current epidemic facing the nation, as well as the nature of these charges, which are serious assaultive allegations, Mr. Harris III. The court also has reviewed and considered the allegations set forth in the investigator's report. During this bond, Mr. Harris III, you are not to purchase or possess a firearm or any dangerous weapon. Do not go back to the area or premises of 6526 Hayden, Detroit, Michigan. And absolutely no contact during this bond with Ashley Carter. That means no contact, sir, of any kind, orally, in writing, through a third person at their place of residency, employment, or through any forms of social media. Absolutely no contact. Is that understood?
Yes, sir. I have a question, sir.
Go ahead.
6526 is my place of residency. A 16500 Green Line is Ashley's.
So she does not stay at the area of 6526 Hayden Street?
Ashley stays 16500 Green Line Street.
And so my question is, answer that question. She does not stay or reside at the Hayden Street address. Is that correct? She does not, as you're telling the court?
That's correct, sir.
Okay, so Mr. Harris, I appreciate that information, and the court is striking that condition. The court does see that she has the address also listed on the Green Lawn Street address. So the court striking that condition of not entering that premises or area. Still have absolutely no contact with Ashley Carter of any kind. Is that understood?
Yes, sir.
Thank you. And Mr. Harris III, the court, given the information alleged in the investigator's report, which is very serious and assaultive, given the court's concern regarding the safety of Ms. Carter, for that reason, you'll be fit with the GPS tether prior to release. Your bond is $10,000 personal bond. You're being released on a personal bond, Mr. Harris III. Good luck. I hope it works out for you. No contact with Ms. Carter. You're welcome. Good morning. Your name, please. I apologize. Your name again?
Raul Sanchez.
Thank you, Mr. Sanchez. Good morning, sir. Mr. Sanchez, you're here for case 2005881, People State of Michigan versus Raul Ivan Delfino Sanchez. Sister Counsel.
Yes, Stephen, hearing on behalf of all counsel, and we were reading out the information, and we asked the plea not guilty.
Thank you. Court wait formal reading and her plea of not guilty. Mr. Sanchez, the court is scheduling a probable cause conference, sir. You must attend on December the 16th, which is a Wednesday, 8:30 a.m., 36th District Court in front of Judge King. That hearing, Mr. Sanchez, will take place via Zoom, which is an off-site streaming technology. You'll get information on how to connect for that Zoom hearing in front of Judge King before you release, but it is your responsibility to connect on time. Do you understand?
Yes, sir.
Thank you. Not guilty, please enter it as the bond. Thank you, Sister Counsel. Mr. Sanchez, this is a serious allegation. It's a felony charge. It is not assault if the court considers your ties to the community, the information provided by counsel, including but not limited to your employment status as a machine operator, his least ability to post bond, as well as the court's unaware of any criminal convictions or capious history. The court's read and reviewed and considered the information alleged in the investigator's report, as well as the current epidemic facing the nation. Mr. Sanchez, it does not appear you have a valid driver's license. Is that true? Do you have a valid driver's license, sir?
Apparently it's suspended, so no, I do not.
Okay, so there'd be no driving during this bond. You do not have a valid driver's license, so there's no driving. Do you understand?
Yes, sir.
And you are not to purchase or possess a firearm or any other dangerous weapon. And during this bond, there's no use of alcohol, no marijuana, and no illegal controlled substance. Is that all understood?
Yes, sir.
Thank you. Mr. Sanchez, for the reasons stated, you'll be released on a $7,000 personal bond. Good luck, Mr. Sanchez. I hope it works out for you. Make sure and listen to the court. Okay. Jarvis Larkin. Okay. Yes, please. Is it going to be a... Okay. And DDC, whenever possible, could we get number 10 back, Jarvis Larkin? Council wants to readdress bond on Mr. Larkin's matter sometime before the end of the morning. Thank you. Thank you, sir. Good morning. Your name, please.
Morning, Jarrell Fox.
Thank you, Mr. Fox. Good morning to you. Mr. Fox, you're here for case 2006045, People State of Michigan versus Darrell Anthony Fox. Thank you. Also known as Darrell Fox. Counsel. Court waive formal reading and her plea of not guilty. We'll get to the court dates in a moment as to bond. Thank you, Sister Counsel. And please mark Mr. Fox's file medical for the reasons stated by counsel. Mr. Fox, this is a very serious allegation, sir, and it's an assaultive allegation. The court takes in consideration the information provided by your attorney, including but not limited to your employment status as it relates to ability to post bond. Court's unaware of any capious history or criminal convictions in the past. These are serious assaultive charges. The court considers the current epidemic facing the nation as well as the information and allegations set forth in the investigator's report, which gives the court concern regarding the safety of Miss Ramsey, the alleged victim. Mr. Fox, also appears you have ties to the community, and the court takes that in consideration upon bond. During this bond, sir, you are not to purchase or possess a firearm or any other dangerous weapon, and do not go to the area or premises of 17645 Hoover, Detroit, Michigan. And absolutely no contact with Nakia Ramsey. That means no contact of any kind, sir. No contact orally, in writing, through a third person, at her place of residency, employment, or through any forms of social media. No contact with Nakia Ramsey. Is that understood?
Your Honor, that address, that's where I stay at. That's my home.
Does she reside with you?
No, she don't.
Is she on the does she stay on the Gaylord Street address?
Yes, Gaylord.
Okay, so there's to be no contact with Nakia Ramsey. The court will strike the conviction about the Hoover address, but absolutely no contact with Miss Ramsey as stated. Is that clear?
Yes.
And not to purchase or possess a firearm or any dangerous weapon. And you understand no contact with Miss Ramsey, correct?
Yes.
Thank you. Sister Counsel, do you have something? I apologize. Thank you. And based on the information alleged in the investigator's report and the nature of these charges, you're to be fit with the GPS tether prior to release. Your bond is set in the amount $5,000, 10%. Good luck, Mr. Fox.
What's his court date?
Oh, I apologize. Thank you, officer. Mr. Fox, thank you, ma'am. Mr. Fox, you have two court dates. You must attend them both. A probable cause conference November the 25th, which is a Wednesday. And sir, you have a right to a preliminary examination the following Tuesday, December the 1st. They're both at 8:30 a.m., 36th District Court in front of Judge Jones. Mr. Fox, both of those hearings, sir, will take place via Zoom. That's an off-site streaming technology. If you make bond, you'll get information on how to connect for those hearings. But it's your responsibility to connect on time, November 25th and December the 1st, 8:30, 36th District Court in front of Judge Jones. Good luck, Mr. Fox. Thank you, officer.
Is it a personal or?
No, it's $5,000, 10%. That's $500, sir.
Okay, is it possible? Because I work, I got a job, and I got to do skilled trades. I be in the boom lifts. I be everywhere. Is it possible if I don't have a tether because I'm everywhere,
No, the court's going to.
I'm gonna go to court. I'm gonna hire my own attorney. I have no reason to run, no hide. So I'm gonna come to court.
Mr. Fox, and I appreciate that. And the tether is not for the concerns the court has regarding your appearance to court. The court has no reason to think that you will not appear based on anything in the past. The tether, Mr. Fox, is to ensure the location and to make sure that you have no contact with Miss Ramsey. And that's given the information alleged in the investigator's report, which are very serious concerning allegations that you assaulted the individual in a number of ways, including but not limited to allegations of hitting her in the face, slamming her head in a wall, and then proceeding to strangle the alleged victim. And so the court, those are just allegations, Mr. Fox, but I wanted to give you the information that concerns the court, and that's the reason for the tether.
Was the warrant? When was the warrant? I don't even know because I got pulled over. That's when I came in. If I knew I had
The warrant was signed. The warrant, Mr. Fox, was signed on or about September the 16th of 2020. This allegation took place June 13th on or about of 2020. So the warrant was signed just over 3 months later. Mr. Fox, are you working today? Are you currently working as of right now, given the current shutdown in the governor's shutdown?
Yes, I am.
What hours do you work?
I work from 2 to 10:30. That because like right 2 to 10:30. Because like I said,
2 p.m. to 10:30 p.m.
Yes.
Okay.
Because I have no reasons to go.
And Mr. Fox, the court will allow you to leave for work. What hours of the day do you work? I mean, what days of the week do you work, sir?
2 to 10:30. I know I got 2 other kids also, and then I have to pick them up. You know, they come over. Just having to tell.
Well, Mr. Fox, you're on a bond, so that your normal process of life is not going to be the same until you take care of this matter while you're on the tether. There's no going out and about, and that's to be clear. The court will allow you to go to work, but otherwise you're to be at home as ordered by the court. What days of the week do you work?
So that's the only thing I can do is just work?
What days of the week do you work, sir?
I work 7 days a week. And then sometimes they'll call me in. I work 14 hours a day. Like my hours.
Mr. Fox, if you're out and about and you're not working, and then it's a violation of the bond, and then the court could revoke the bond and lock you back up just for not listening to the court. So if you have any ideas of going out and about and continuing normal course of your life that's not authorized by order by the court, you're inclined. It's possible that you're going to get locked back up and incarcerated just for not listening to the court. So I tell you that a number of times, Mr. Fox, because it's very important to listen to the court, and you will be being monitored. So if you're anywhere but work, you're inclined to get locked up, sir. The court will allow you. How long does it take you to get back and forth to work?
It takes like 45 minutes. You know, I'm a contractor. You know, like I work at Chrysler, I work at Shep, I work at JNAP, I work at GM. I'm everywhere. I'm a contractor. I'm a unionized 1102. I'm a contractor.
Okay, so the court's going to give you an hour each way, Mr. Fox. You said it takes 45 minutes. The court will give you an hour each way. You can go to work 1 p.m. to 11:30 p.m.
So can I
Excuse me?
early? That's what I'm saying. So can I leave home early, or I gotta be out the house at a certain time?
That's what I just told you. The court's giving you said it takes you 45 minutes to get to work. The court will give you an hour. You can leave your house from 1 p.m. to 11:30 p.m. That gives you an hour each way to get home.
An hour each way to get home? What if I get into traffic? Like I say, I'm a contractor. They might transfer me somewhere else. That's what you're failing to realize. I'm a contractor. They might send me somewhere else. Like I'm an essential worker. I'm working.
Well, I cannot predict the future, Mr. Fox. That's why I asked you where you work and what your hours were. I don't know where you work or what you do. You told the court that your hours were. Mr. Fox, you can't talk over the court, sir, or else you can't hear me. You told the court the reason.
Your Honor, please the court. We thank the court for its bond. Maybe we could have an opportunity, counsel, to speak with Mr. Fox again, and if there is additional information that we think we need to present to the court on behalf of Mr. Fox, we ask for the opportunity to do so.
Oh, absolutely. That's at any time. You can always readdress. But Mr. Fox, I want to be clear. That's why I ask you those questions, sir, at your hours of employment, because I want to give you enough time to go to work. And so the court's allowing you to go to work, and the court's allowing you 1 p.m. to 11:30 p.m. If you are transferred or if you're sent somewhere else, then you need to contact the judge or your attorney and see if this bond can be modified based on if you get transferred somewhere else. But based on what you're telling the court, you work from 2 to 10:30. The court's giving you an hour each way. You said it took 45 minutes, so that's an extra 15 minutes, which is 33% more than you asked for. And so the court's satisfied that that's enough time.
And with that, I advise Mr. Fox to protect his rights and to continue at this point to remain silent. He asked that the deputies give us an opportunity to re-interview Mr. Fox so that we can represent to the court any additional information he might want us to have, want the court to have. But Mr. Fox, at this point, As counsel, we are advising that you remain silent. Protect yourself and remain silent.
That was your attorney speaking. Do you have anything else you'd like to say?
Yes, because at the, end, the only thing I'm saying, so say for instance, if my job, okay, you're not my attorney, I'm gonna hire my own attorney, ma'am.
I know, so we want to talk to you again. So we're gonna just ask the deputies if we can talk to you again, okay?
I make $40 an hour. I make $40 an hour.
Okay, Mr. Fox, you can say whatever you like. I hear you, Mr. Fox. You can say whatever you like. I hear that you make.
You give me a time though. My hours fluctuate. I'm a contractor. I have no reason to lie. My hours fluctuate. I'm telling you, I don't have no reason to. If I knew I had a warrant, I would have hired me an attorney. I would have turned myself in. I would have. I have no reason to run. I have no reason to go over there. Whatever the victim said, I have no reason to do that at all, Your Honor. All I'm saying is I'm a contractor.
And Mr. Fox, you've stated that you're a contractor a number of times, and the court hears and understands that. Anything else you'd like the court to consider, sir?
Okay, you just don't care.
And that's not at all, Mr. Fox. You can continue to talk, and I'll take into consideration whatever you'd like, sir.
You're not taking into consideration at all, because I just told
I'm
you
not listening and doing what you would like me to do. That may be the case, but I am definitely considering, and it's disrespectful, Mr. Fox, to you to tell the court.
I'm gonna stay away from her. I'm gonna tell her. You're gonna see where I'm at. You're gonna be able to track me. If I'm stalking her or harassing her, you can track me. Why do I have to be on the time period? So now I have to let my job know, okay, well, I'm gonna tell her I got a call. This is looking bad. I went to school for 4 years for this. This is making me look bad. That's what I'm saying, Your Honor. I mean, come on. I don't have no reason to go over there. I'm on tether. You can check me anywhere.
Mr. Fox, these are serious allegations, sir. They're assaultive allegations. 3 assaults.
I'm gonna fight them.
Okay.
I'm innocent, proven guilt. I'm gonna hire me an attorney. Yes,
and I wish you the best of luck, Mr. Fox. Is there anything else you'd like the court to consider, sir?
No.
Good luck. If they want to bring it back, then it's up to her. I'll listen if they want to make additional arguments. I'm sorry. Good morning. Your name, please.
Clarence Murray.
Thank you. Good morning. You said Corius Bird?
Clarence Murray.
Clarence Bird. I apologize. Mr. Murray, good morning, sir. You're here for case number 200-61924, People State of Michigan vs. Clarence Lee Murray. Sister counsel.
Clarence Murray, waive the reading information on his.
Thank you. Madam Clerk, is this just a duplicate? We just had 2 of each? I think they look the same. You want me to just leave them in the file? Okay. Thank you, Mr. Murray. And you said waive formal reading, counsel?
Yes.
Court, thank you. Court, waive formal reading under plea of not guilty. Mr. Murray, the court's scheduling a probable cause conference, sir. You must attend December the 16th, which is a Wednesday. That's 8:30 a.m., 36th District Court in front of Judge Giles. That hearing, sir, will take place via Zoom. That's an off-site streaming technology. Mr. Murray, you'll get information on how to connect for that Zoom hearing before you're released, sir, but it's your responsibility to connect on time. Understand?
Yes, sir.
Thank you, sir. Not guilty is entered as the bond.
Thank you so much, Your Honor. This is not a call for Mr. Murray, unfortunately, he's 25 years old. He's been in jail, I think, just around 48 hours at this point. It has been entered each schedule, Your Honor. I think it was scheduled either yesterday or today. Mr. Murray does need to get back to work for last Saturday. He does have the technology to participate in any upcoming Zoom hearings. Again, it's non-assaulted. Mr. Murray does.
Thank you, Sister Counsel. Mr. Murray, good luck with your upcoming job interview, sir. I hope that works out for you. Mr. Murray, this is a very serious allegation, sir, but it is non-assault. The court takes consideration that court's unaware of any capious history or criminal convictions. You have ties to the community. Court considers the information provided by counsel as well as the alleged investigator's report and taking into consideration your lack of employment status, as counsel says, relates to the ability to post bond, as well as the current epidemic facing the nation. For those reasons, Mr. Murray, your bond will be set $3,500 personal bond. You're being released on a personal bond, sir. Listen to the court. Good luck.
Thank you.
You're welcome. Yep, they're here. Oh, okay. Christopher Sinclair. Is that the Sinclair one? Brandon. Good morning, counsel. Who are you here for, sir?
Good morning, Your Honor. I'm here on Brandon Scott.
Brandon Scott. Is that?
Yes, sir. It's two matters.
Oh, thank you, sir.
I'm sorry.
Brandon Jordan. Is that who you're? Brandon Jordan?
Yeah, I apologize. I said it's first.
No worries.
Yeah.
No worries, counsel. Officer, could we call them and let them know that we're ready? And Officer Love is calling up. He's housed at a separate division in MDOC. Officers calling up and having them connect. Counsel, as soon as they connect, we'll handle your matter. We have everything ready on this end, okay?
Yes, sir. Thank you.
Thank you for your patience. Good morning, sir. Your name, please. Your full name?
Devin Rayner. First name Devin.
Devin Rayner? Say your full name, sir.
Devin Rayner.
Thank you. You can put your mask on, sir. I can hear you through it. Thank you, though. Mr. Rayner, good morning. You're here for case 200619925, People, State of Michigan versus Devin Tyler Rayner. Sister counsel. Thank you, counsel. Court waive formal reading and her plea of not guilty. Mr. Rayner, the court scheduling a probable cause conference, sir. You must attend December the 16th, sir. That is a Wednesday, 8:30 a.m., 36th District Court in front of Judge Giles. That hearing, Mr. Rayner, will take place via Zoom. That's an off-site streaming technology. You'll get information on how to connect for that Zoom hearing before you're released, but it's your responsibility to connect on time. Is that understood?
Yes, sir. Yes.
Thank you. Thank you, Mr. Rayner. Not guilty is entered as to bond, counsel.
Is 24 years old. He's had that job. Is concerned about being incarcerated over at the Wayne County Jail during the pandemic and that
Thank you, counsel. Mr. Rayner, your counsel has advocated well on your behalf, and the court takes into consideration the information she provided. You have ties to the community, no capious history or criminal convictions the court's aware of. This is a very serious felony allegation, but it's non-assaultive. Court considers the current epidemic facing the nation was the information alleged in the investigator's report and employment status as counsel stated lack of as it relates to ability to post bond. During this bond, Mr. Rayner, you are not to purchase or possess a firearm or any dangerous weapon. No weapons, understood? Thank you. Is that a yes? Yell it out.
Yes.
Thank you, Mr. Rayner. Thank you, sir. And for that reason and information placed on the record, you'll be released on a $7,500 personal bond. Good luck, sir. I hope it works out for you. Thank you. Yes, sir.
We have Larkin ready to be re-interviewed or seen by you?
Yes, please. Seen by me, I believe. They just they want an update or speak about bond again. So if you could bring Mr. Larkin out at your pleasure.
Copy that.
Thank you. Good morning again. Your name, please.
Jarvis Larkin.
Thank you. And this is a recall at request of your attorney on case 1806124 People, State of Michigan versus Jarvis Jarrell Larkin. Bond was an arraignment was previously held this morning. Bond was set for the capious appearance, please.
Forfeit hours to have a contact with the team who will be doing this matter going forward. And this court authority to reduce the bond to $5,000 temporary.
Thank you. Okay, Mr. Larkin, your attorneys have gone above and beyond. The bond was set at $25,000 cash or surety. They've spoke to the judge that you're assigned to and have the judge has authorized the court, if the court sees fit, to amend bond. And the court will do just that for the reasons that were previously placed on the record, the nature of this charge, as well as the lack of criminal convictions the court's aware of, and the information alleged in the investigator's report, including your ties to the community and the current epidemic facing the nation. The conditions stay the same, Mr. Larkin. There's no use of alcohol, no marijuana, no illegal controlled substance, and you're not to purchase or possess a firearm or any dangerous weapon. Your bond is now set $5,010%. Now that's a $500 bond. It went from a $25,000 bond down to a $500 bond. It's very important you attend court dates, sir, so you don't get locked back up just for not showing up. Does that all make sense?
Yes, sir.
Okay. Good luck, Mr. Larkin. Your bond is amended as stated, given the reasons placed on the record and the authority as stated by counsel. And your court dates stay the same.
Okay.
You're welcome. Thank you, DDC. Appreciate you, as always.
Your Honor, would they
Yes, sir.
would they like to interview Fox again, or should I put my guys up and meet you on the female side?
Sister counsel.
They're asking for me to go off camera too.
They want to know if you want to interview Fox again or put them up.
Yes, they want to, yes, we'd like to.
Counsel would like to interview Fox again on camera too, if possible. Thank you for asking.
Okay, you want to go to the female side, Your Honor?
Whatever works for you, sir. We just have the one female.
Okay, I'll meet you over there.
I appreciate you. Thank you. Meet you over there. Thank you. Counsel Sinclair, officer, what did they say? Counsel Sinclair, they're not answering at division. Madam Clerk is attempting to call as well. Please, thank you for your patience.
Okay, no problem.
Thank you, Claudia.
My name is Bree Davis. Good morning, sir.
Thank you, Miss Davis. Good morning to you. You're here for case 1906-0764, People State of Michigan versus Dory C.N. Monique Davis. Sister counsel.
It's Bree and Dominique, not Monique.
What was that, ma'am?
It's my middle name starts with the D, not an M. They messed up on that.
Oh. Okay, thank you for that. I'm reading what's on the complaint, but thank you for the clarification, Sister Counsel.
Okay.
Stevenson is here on behalf of Ms. and Davis, waives the reading of the information in this, and we ask that we not go further on her behalf.
Thank you, Sister Counsel. Court waive formal reading and her plea of not guilty. Ms. Davis, the court is scheduling a probable cause conference, ma'am. You must attend Wednesday, December the 16th. That's at 8:30 a.m., 36th District Court in front of Judge Giles. Ms. Davis, that hearing will take place via Zoom. That's similar to the technology. It's an off-site streaming technology similar to what we're using today. Before you're released, you'll get information on how to connect for that Zoom hearing, but it's your responsibility to connect on time. Do you understand?
Yes, sir.
Not guilty is entered as the bond, Sister Counsel.
Thank you, Your Honor. Ms. Davis, wants the court to know with regard to the opinion that he was working for the last 7 years.
Thank you. Ms. Davis, this is a very serious allegation, but it is not an assault. The court takes into consideration the information provided by your attorney. The court is unaware of any case history or criminal convictions. The court considers your employment status as counsel states. It relates to ability to post bond as well as your ties to the community. Ms. Davis, do you have a valid driver's license?
No, sir, I only owe Detroit, and then I will have them.
Okay, so there's no driving during this bond. You do not have a license, valid license as stated, so no driving. Do you understand?
Yes, Your Honor, I understand.
And you are not to purchase or possess a firearm or any other dangerous weapons during this bond. No weapons. The court, given the information stated by counsel, placed on the record the nature of this charge as well as the epidemic facing the nation and the information alleged in the investigator's report. For those reasons, bond is set as well as your ties to the community. $7,000 personal bond. You're being released on a personal bond, Ms. Davis. Good luck, ma'am. Listen to the court.
Thank you, Your Honor.
All right, this way, Dave.
Thank you. Thank you, officer. I appreciate you. I guess we'll go back to the male side and see if they want to readdress Mr. Fox. If not, then we'll see you this afternoon.
Okay, I'll meet you over there.
I appreciate you. Thank you, sir. Yep. What's that? You like them?
When I called, it didn't even like $100 or anything.
You like them? I apologize. What's that?
Something really quickly on the Fox.
Okay, thank you. So I think, can I get that Fox file back, please? And then this is thank you, Claudia. Thank you. And then this one was a Zoom hearing they didn't show up on. And then everything else is finished besides the MDC. Yeah. Thanks, Claudia. Thank you, Aaron. Thank you, Officer.
Come back in.
Come on, yeah, come on.
Okay, good afternoon again. This is a recall on case 200-60465, People's State of Michigan versus Jarrell Anthony Fox, also known as Jarrell Fox. This is recall at counsel's request regarding a revisit of bond. Mr. Fox, please state your name again.
Jarrell Fox.
Thank you. And counsel, your appearance.
Philip Ray on behalf of Mr. Fox. I'm talking to Mr. Fox. And I would ask the court, and I would note that this matter goes back to June 13th. Mr. Fox doesn't wish to have contact with Wayne. Now, I do understand the court, Mr. Judge, I have a lot of respect for the court. I do know the charges are serious. Now, Mr. Fox explained to me the circumstances, and obviously he's going to plead not guilty. He said he was attacked. He's going to defend himself, but we can't get into the facts here, Judge. I don't understand that. He has a job, Your Honor, that fluctuate hours. My concern is if he has a tether, the tether folks will not allow him to go to work.
The court's indicated, ask him what time he goes to work. He told the court, ask him how long it takes him. He said 45 minutes. I gave him an hour each way, and so he can go to work, and the court's indicated on the MIT.
My only thing would be if the court could put the only restrictions that he stay away from the complaint, and maybe like within 100 feet of her house, because his job fluctuates. Some days he might work from 7 to 4, other days he might work from 4 to midnight, and it fluctuates. And that's the only reason why I was concerned about the job. I understand the tell Judge, I just don't want, I want the restriction to be do not go near her. There's a PPO, to my understanding too. So he understands that he even said, I couldn't go near anyway, Mr. Ray, you know what I'm saying?
Well, Mr.
PPO, Judge, I do understand that.
Yeah, and Mr. Fox gave the court additional concerns. He indicated that he wanted to basically go out and about and continue to and be with his children, go out and do things in life. And the court,
Not during this case, Judge.
well, that's what he'd indicated to the court, and that's his concern. Is the court allowed him to go to work? Where the court has concerns, and as counsel is aware, is these allegations are assaultive allegations, and the investigator's report indicates allegedly repeated assaulted allegations. It's alleged that he not only slapped her in the face, he then proceeded allegedly to slam her head into the wall, then proceeded to strangle the alleged victim. All of this allegedly occurred while the victim was having a young child in her hand. And the court is concerned. The court took all of that into consideration and has allowed him, Mr. Fox, to go to work. The court asked Mr. Fox's employment schedule. And as counsel is well aware, if his job changes, I cannot predict the future. If his job hours changes, he can always contact the court and get an amended order through a counsel or through an attorney. I cannot foresee the future and know what his schedule will be like. I asked him and he told the hours, and so I gave him an hour each way on each of the hours. And he doesn't know the future either. He's not sure if his hours will or will not change as far as the court hears.
Because if they do, I know how tether works, and sometimes it's very difficult once you get locked into those tether hours. Say his job calls him and says, hey, I need you to come in right now. He can't just automatically just go in because the tether folks are like, no, you can't leave. And he'd have to come back to court just to change that. And that's my biggest concern. I understand the tether. I understand the court's position. My thing was to not make it a restricted tether at all, except having absolutely no contact with her residence or anywhere around her. That was my thing, not to restrict it so that he couldn't come and go, but just to have a tether on it for the complaint's sake. That's my biggest thing. This was not going to be a complaint.
Well, it's not 7,500.
I understand what the counsel's saying, and I guess the court could fashion it in this form: is
So change it.
if hours change, he's allowed to continue to work
as long as this is his job.
As long as this is his job, and he is to carry proof of that work with him. And I want Mr. Fox to be Mr. Fox. I want you to be clear. What don't you understand, or what's bothering you, sir?
You said show proof of what? You say show proof of work?
Yes.
How? What, my check stubs?
No, something that your hours have changed. Something in writing that somebody, a supervisor or somebody, could write up that your hours changed, that you could carry with you if you were stopped, that you could show an officer that your hours have changed, but it would have to be written and approved by somebody at your work.
I mean, if I have to, but I mean, I'm just involving other people in my case. You know, this is allegations. You know what I'm saying? Like, I'm not trying to keep it a secret.
We're not going to get into the facts right now. The facts are the facts. We can't get into the facts. You know, all they are is allegations. That's all the court has is one side of the story. They don't have your side is coming later. This is just for purposes of bond.
And that's all accurate, Mr. Fox. And the court stated a number of times these are just allegations, but there's concerning allegations, and the court has concerns regarding the safety of the alleged victim for the reasons that's placed on the record numerous times. And so the court is trying to work with you as far as your employment goes. If that would help you, the court will add that on the order. Otherwise, the court will leave it alone. Do you want the court to add that onto the order, that if hours change, you're allowed to continue to work if you have verification from your job?
Yes.
Do you want me to add that, Mr. Fox?
Yes.
Okay. Anything further, counsel? Anything further, Mr. Fox?
No. I'm just.
Good luck.
We talking about bond and everything. It's just allegations. But you talking about me understanding
Hold
what
on 1 second, hold on 1 second, because we're in a good place right now, so let's.
Mr. Fox, you were very.
And I understand Mr. Fox's concern, because he was there, he
he said
knows exactly what happened, we were, go
domestic
ahead.
violence.
It's a process, you have to go through the process, Your
I
Honor.
understand Mr. Fox's concern.
Thank you, Mr. Fox.
Anything further, sir?
No.
Good luck, Mr. Fox. DDC, thank you for your assistance. As always, I appreciate your back and forth and helping with the court's docket. Be safe, and we'll see you this afternoon.
You're welcome, Your Honor.
Thank you, ma'am. Counsel Sinclair?
Yes, sir.
What do we have an update on him? No. Sir, they're not answering at the division at MDOC. They're supposed to call in at 11:30, and they have not. We've attempted to call them to try to reach them to let them know we're ready on the arraignment, which we've been ready on since this morning, and they're not answering. So we're calling again right now.
Okay, thank you.
You're welcome. Thank you for your patience.
No
Excuse
problem.
me?
I'll send an email to Miss Gray and see if she has maybe a different contact person or phone number.
Yeah, I think Madam Clerk has just spoke with Miss Gray, but feel free to do that if you can help us in any way. Then we'd take your assistance. But I think we've already tried that avenue.
Okay, I mean, if
we haven't.
Then I'll just.
We haven't heard back from Miss Gray yet, though. So if you can get a quicker answer, anything would help out.
Yes, sir.
Thank you. How's it going, Hopkins? Morning. Okay, Madam Clerk, the court had updated Mr. Fox's second page.
So the bottom of it changes the condition.
Nothing's changed besides that second page on the tether conditions. Thank you. Thanks, Aaron. Appreciate you. So we're just waiting to hear back.
It's only the one phone number on there, so I'll call them for you.
Okay.
I guess they're, say that again,